Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone, and happy Friday. It is August 1st, 2025, and my name is Pam Esquire, also known as Your Law Intellect. I hope you guys are having a fantabulous Friday. It has been one of the longest weeks of my life, but we made it. We made it, and we also made it to the government's response to Diddy's plea for bail. And if I were to sum up the document and I just kind of skim through it, you know how I do. If I'm going to read it line by line, I might as well do it with you. But based on my skimming, they're basically saying, yeah, no. Nah, buddy, not going to work. So their main arguments, just to give a summary, is first of all, they're saying that the Diddy's team, the judge has already made a decision. They have already briefed it. They've already been in front of the judge. There should have been a motion for reconsideration, and it was not even brought appropriately. Then they say it's no extraordinary circumstances. And they go over a couple of the cases, I think, related to individuals that got bail, and their circumstances was, of course, different than what Diddy is. But I think we all know that because there are really no circumstances, apparently, that even fit Diddy's case. And then they go into the MDC, and it ain't that bad no more. They've been fixing it. They've been working on it. They've been making repairs. I wonder if any of the AUSA want to go there and check it out and spend the night and see how good it is. Like how they do Undercover Boss. I wonder if one of them will go in there and see how great it is, and if they feel like it's been repaired enough that it's not a constitutional violation. But anyways, and yeah, they said basically you ain't coming with nothing new. The judge is already, you ain't came up with nothing for him to consider. Okay, so let's just, and it was signed by, of course, all the individuals that were on the case, except, Maureen got fired. So I don't think her name is on there. But you have the new interim AUSA who is on the thumbnail, whose name was on there instead of Damian Williams. So of course that would be a Trump appointee, who is still, I guess, saying that maybe he should not have bond as well. So we're going to go over that right now. If you guys could be so kind as to hit that like button and subscribe to the channel. I just wanted to give a brief synopsis. Of course, there are other points that were raised in there. They brought up the argument about the U.S. Attorney's Manual, and they're saying that y'all bringing up the old stuff. It's been changed, and I'm gonna need y'all to speed up. And so there were a few other things that they talked about as well. But basically, they fighting it. They was like, the judge already made a decision. He made the right decision, and that's that. So for those that's at work, that's your summary. But for those that can sit around here and listen to this document, I'm going to need y'all to listen to this document with me. But before you do so, make sure you hit that subscribe button and like the video and let people know that we are on. All right. Good to see you, Gwen. It's the Rocks. Good to see you. Good to see you, Miss Buckeye. How is he a danger? So in the document, when we get into it, they are discussing all of the violence that came up during the trial. Now we all know, and I'll give some commentary when we get to that portion, but that's basically what they're referring to. And apparently there was some alleged violence that maybe we did not hear about, which we probably heard on the internet, with some of these people that the cook, she went on and she went all over the internet about how she was scared and all of that. And it's a lot of people that have come out on the internet that weren't necessarily evidence of which were making these allegations against Sean Combs as well. So the government redacted part of it, so I'm assuming it was information that the judge deemed inadmissible, or the court deemed inadmissible. Shantae 101 said these rich black men need to start using their resources to make major changes. If they'll do it to him, imagine what they'll do to some. And that's the point. I was like, I hope he gets out. Now, a lot of people, I've never really watched the Chrisleys, but because they are totally taking over my timeline on TikTok, I have been watching some of their videos. And you guys know, apparently they had a reality show, and they were charged and convicted of tax fraud or something that had to do with taxes. I have no clue about the case, so everything is just what, of course they maintain that they paid their taxes and they were wrongfully convicted. And I think Julie was supposed to get out like next year, but anyway, Trump pardoned them. And one thing I can say about Todd is it almost feels like Todd being in there was like destined or something, because the way he is out here windmilling for folks, and allegedly the warden where he was at, he said that they got fired. He was telling what was going on the inside, giving the information to their daughter Savannah, who was doing press conferences and going on shows, and because they had the resources and the reach. So I agree. The problem that a lot of people have is that when it doesn't affect them in their household, they don't care. So sometimes it takes for you to know the same thing that happens to other people can happen to you. You are not untouchable when it comes to this government. And I think if many people cared more about other people, and not just selfish and just all about them and what they're going through, then maybe there would be some change. So perhaps him going through some of this will urge him to be a fighter, because a lot of the people here are exonerees here. They're like a whole community and a brotherhood or sisterhood within themselves, and they always support the next person in court trying to get out, the next person who has a parole hearing, I told you I had a court of appeals hearing that I attended, and they randomly were there because it was about an issue that would affect that. So does everyone do it? Like, I can't say that has happened to me, but I know that it's a cause that was worth fighting for. So I spent some of my time, a lot of my time, fighting for that. So I agree. I think these black men need to not get to a point, and not just black men. I think all men. It's about humans. We're all human, mankind. I think that when you have the reach, the resources, the connections, the abilities to actually make change as something outside of you, and it's brought to your attention, then you should make some change, because that's how change occurs. Because for Todd Chrisley to be in prison and all he did was like feed stuff to his daughter, and now people getting fired, changes are made, they trying to shut down facilities. And I think he even made it into, he announced a Netflix series. It might not be Netflix, but some streaming platform, of which now they're going to do a kind of like a docu-series of the men he was in there with, because a lot of them were younger, and they said he almost became their father while he was in there. It was just a lot. So it's very interesting. And I've never been a Chrisley person, didn't know much about him, but I'm not gonna lie, them little clips that come down my timeline when he discusses prison is very interesting to me. So hopefully, he does that and he cares. What up, though? Ain't no fun when the rabbit got the gun. When do we get the judge's decision? I'm gonna assume it's gonna be a hearing, unless the judge. Well, he doesn't have to do a hearing because in theory it's a reconsideration, so he can do it on the pleadings. So we'll see. But we also have to keep in mind that allegedly, according to news outlets, I don't know how true it is, but according to I think it might have been TMZ or something, said someone close to the situation said that the legal team has talked to Donald Trump and he's considering, but he's actually looking to see what happens with bail. So if they don't give him bail, which is interesting because again, this is a Trump interim appointee that is the AUSA now, who is fighting against this bail. But if they don't give bail, apparently he may make a decision. And for him to say if he doesn't get bail, I'm gonna make a decision now, I mean, it kind of leans towards that he may just go ahead and pardon him. But we'll see. You know, I ain't got no inside information. I don't know none of these people, despite what people think. They think I'm just a paid informant or something. I don't know nobody. Okay. I'm just reporting what comes on the docket. Hey, Sunflower, good to see you. Mark Jag said the violence was that of a jealous boyfriend and he was never convicted of that. That is true, but they apparently, when it comes to bail, as you see, before he was even bail is not supposed to be meant for punishment. And as you see, especially when you haven't, prior to him even going to trial, he was basically he was denied bail in substance because of that video. The video had a big impact on, like, it was cited by the judges. People did not like the way that video were looking up there at the SDNY. So to say that, I get what you're saying, but they still use it in a way, in my opinion, I think it's still used as almost like you're guilty until you're proven innocent, as opposed to the other way around. That's why you have certain states that's trying to implement systems like the no cash bond and all of that, because you may do a bunch of time and then all of a sudden the police come with, oh, my bad, we had somebody come in and confess, and you done a year because you just can't afford the bond or you didn't get bond. So yeah. Ms. Buckeye, thank you for the super chat. Said, let's support the platform. Help Pam reach the goal for just the thumbs up. Thanks. Yes, if you could just thumbs up the video so we can be in the algorithm, that would be great. Glamour W1 said, good morning. Thank you so much. Uncle Mario, happy Friday, Pammy Pam. Happy Friday. Thank you, thank you, thank you. Yeah, we got a goal right now of 5 super chats. Y'all know y'all can get them super chats now. Come on. It's 5 of y'all that can get the go. Okay. We got some top supporters on here. I guess they do the little badge things. I just noticed that on other people's platform. I didn't even know they did it. I was like, what is this? But yeah, thank you to all the top supporters that comment, subscribe, and give not subscribe, but like and give super chats. Apparently you can get top fans in the top 5, and then I'm able to see who the top people are and all of that. Dana White, the owner of the UFC, was on camera slapping his girlfriend around and served 0 jail. Well, he wasn't even convicted of domestic violence, so I don't think they care about that for real. They're using it to keep him, to say that you're a danger to society, but that was not a part of his conviction. Now, when it comes to his sentencing, you are not supposed to. I think it was the charged offenses that you're considered, that you were deemed not guilty by a jury. You're not supposed to consider that in the sentencing, but we'll see. We'll see how it goes. All right. So this is the letter that was filed today. And they start out with, despite the court's clear rulings that the defendant must be detained pending sentencing following his conviction on 2 felony counts, the defendant moves again for bail. So basically, they like, you keep making us do all this darn work despite what the court said. As the court correctly found after written and oral submissions by the parties on July 2nd, 2025, the defendant's detention pending sentence is mandatory. There are no exceptional circumstances justifying his release, and even if there were, the defendant cannot demonstrate by clear and convincing evidence that he is not a danger to the community. Further, following the court's unambiguous rulings, the defendant now seeks relief without even attempting to demonstrate a reason for reconsideration. Because the defendant's motion fails to demonstrate any of the required showing, he fails to carry his burden, and the motion should be swiftly rejected. They say right now, as soon as you read it, you should just be like, denied. The defendant has presented no reason for the court to reconsider its detention. The defendant asked this court to reconsider its July 2nd, 2025 ruling that the defendant must be detained pending trial, but fails to even address the proper standard for a motion for reconsideration, let alone meet it. This court properly denied the defendant's request for bail on July 2nd, 2025, and the defendant has failed to present any reason for the court to reconsider its ruling. The court should deny the defendant's motion on that basis alone. Whereas here, so this is the law, the defendant's bail application pending appeal was previously denied. A renewed motion for bail is properly considered in a motion for reconsideration by the court. And then they do the case law. That's the standard. And they got the local rules. A motion for reconsideration will generally be denied unless the moving party can point to controlling decisions or data that the court overlooked matters, in other words, that might reasonably be expected to alter the conclusion reached by the court in U.S. v. Fisher. To warrant reconsideration, the moving party bears the heavy burden of showing an intervening change of controlling law, the availability of new evidence, or the need to correct a clear error to prevent a manifest injustice. A motion for reconsideration is not intended as a vehicle for relitigating old issues, presenting the case under new theories, or otherwise taking a second bite at the apple. Indeed, reconsiderations is an extraordinary remedy to be employed sparingly on the interest of finality and conservation of scarce judicial resources. So their discussion, they say the defendant has failed to meet the strict standard for reconsideration. As an initial matter, the defendant's motion is untimely under Rule 49.1D because the motion was filed 27 days after the court's July 2nd, 2025 bail determination. The defendant fails to meet Rule 49.1D's 14-day deadline. So they're deeming this a motion for reconsideration. And when you do a motion for reconsideration under Rule 49.1D, you're supposed to file it within 14 days. One of the things that I told you all is a lot of people do not practice in federal court because it's a bunch of rules, procedures, standards. You got your general federal rules, then you got your local federal rules for that district. Then the court has their own rules. And as long as all of them don't conflict, it is what it is. And you have to know all of them and you have to be mindful for all of them. And so when I first went to, they have in Michigan what is called first year lawyers, and it's like a introduce you to the court, introduce you to the judges. So in my first year after passing the bar, I went to the first year here in Michigan, the federal court, and I promise you, first of all, when you walked in there, you immediately know there's a stark difference from the state court. The state court almost feels like your hood court, and then the federal court feel like the real court that you learned about when you were a kid on TV. That's kind of what it like gives sometimes. And the federal judges just always seem super, super serious. They're not cracking smiles half the time. There's no joke. You know, you might go into one of these district courts around here and the judge come out with their coffee like, hey, good morning, everybody. How y'all doing? We like, good judge, what's that? You know, then they go back. I'll be out in a minute. I'm just going to finish my coffee. Then I'll be out to get to the docket. You're like, all right, judge, that's okay. So then they go back there. That can happen like that. You can go into judges. Like I went to one of the courts in New York, one of them superior courts. I can't remember where. And it was just chaotic. It was so much going on. It was people running in the back, people in the hallway, people in there, people doing that. Federal court is not like that. It is conservative based, and it is exactly what you see on TV on the strictness of it. And the first thing they tell you when I went to that first year orientation / seminar, whatever they call it, the first thing the chief judge said, and I said, I'll never forget it. He was like, you know, that stuff you guys do in state court? Yeah, we don't do that here. Okay. We have rules. You're going to abide by all those rules. We are not your homies. Okay. And if you don't follow the rules, you're going to have a hard time up in here. So my suggestion is you learn the rules of this here court and the federal system, because it's a bit different. So yeah. So they're pointing out the alleged 14-day deadline for reconsideration under the rules. Further, the defendant fails to point to any intervening changes of control in law, new evidence, clear error, or need to prevent a manifest injustice is required. Indeed, the defense previously presented to the court its assessment of the defendant's risk of flight and dangerousness. The defendant's current motion raises no new issues that the court, quote, overlooked in that regard. Similarly, during the bail hearing, the defense put forth the arguments that it argues here with respect to exceptional circumstances, namely that the circumstances of the defendant's Mann Act convictions present exceptional circumstances warranting his release from custody. The court heard defense counsel on that point and rejected the position, finding that irrespective of any exceptional circumstances, the defendant could not establish by clear and convincing evidence that he was not a danger to the community. In addition, as discussed below, the defense raised the conditions of the MDC with the court during the prior bail hearing, but stated the opposite of what they now claim presents extraordinary circumstances. So they said so then they pull up the trial transcript where they say, I want to thank the MDC. The MDC gave us good access to him. They made it work. And Your Honor helped us out a great deal by giving us access to him. So basically, they are using you on you. Okay. What you've said in the courtroom. And now, if it does not comport to what is in your document, they're going to remind you of what you said. And you said the MDC was helping you out where you were able to see your client. The defense cannot now claim that there was an intervening change in the conditions of the MDC to justify the court's reconsideration. But if that's the only statement they're talking about, though, like on the flip side, that's not saying much, because the MDC, the conditions have been talked about on numerous occasions in numerous cases, and judges have even talked about the conditions there. Doing so will relitigate old issues or otherwise take a second bite at the apple, which is not the province of a motion for reconsideration. The defendant has failed to show an exceptional reasons. Okay, so they say even setting aside the defendant's failure to meet or even address the proper standard for a motion for reconsideration, the defendant's motion still fails. So even if the court says, you know what, I'm just going to overlook that they're late, and that they didn't even put the standard that it's a motion for reconsideration, the government is saying they still wouldn't win this motion. As this court previously found, because the defendant was convicted of felons under Chapter 117, his detention is mandatory pursuant to the Bail Reform Act. That's what I told you all in a previous video. I said they're going to respond and talk about the mandatory of the Bail Reform Act. And once again, that's what got Bishop Whitehead remanded. They wasn't even paying him no attention. But because he got out on the internet streets and was talking too much, they was like, you know what? We about to pull up this motion for this bill. You guys to go. And once again, the defendant has not met the requirements of the so-called safety valve in 18 U.S.C. Section 3145C, which requires defendants to prove by clear and convincing evidence that they are not a flight risk or a danger and that exceptional reasons exist making detention appropriate. The defendant's attempt to avoid the mandatory detention provision by claiming that his prosecution under the Mann Act is somehow, quote, unique, is both incorrect and irrelevant to his motion for bail. Moreover, the defendant's argument that the defendant faces exceptional circumstances at the MDC is belied by the factual record, including multiple statements made by counsel for the defendant. There are no exceptional circumstances here, and the defendant's motion can be denied on this basis as well. So they're saying there's nothing exceptional about the defendant's Mann Act conviction. The defendant spills much ink explaining why the underlying facts of his convictions make his continued incarceration, quote, exceptional. And they got the defendant's motion at pages 3 through 9 is where they talk about the Mann Act. So that's what they said. They spilled much ink talking about this. However, the defendant's arguments are baseless, misleading, and run counter to the clear intent expressed by Congress. First, the court should not entertain the defendant's request to override the clear intent of Congress by putting aside the mandatory detention provisions of Section 3143, sub A, sub 2, in favor of examining the facts underlying the convictions. The defendant points to no authority for this novel theory, nor could he, because Congress could not have been clearer. Those defendants found guilty of any felony under Chapter 117 of the U.S. Code shall be detained. And the word shall means it's mandatory, may means it's discretionary. So if it has shall be, then that's supposed to be mandatory. If it had may be, then it would be in the court's discretion. Congress did not say that mandatory detention applies only to some felonies under Chapter 117, depending on the facts underlying the conviction. Congress said that mandatory detention applies to any felony under Chapter 117, 18 U.S.C., Section 3156, sub A, sub 4, sub C. The defendant's Mann Act conviction are such felonies. So they're saying it's under the chapter, it's mandatory detention. Encouraging the court to consider the facts underlying the defendant's convictions as exceptional reasons under Section 3145 defers Congress's clear intent to make detention mandatory with respect to certain categories of felony conviction. District courts certainly have broad discretion to consider what constitutes exceptional reasons, but accepting the defendant's invitation would take away the congressional intent underlying the mandatory detention provisions contemplated by the Bail Reform Act. Instead of creating a carve-out for Mann Act conviction that follow a particular fact pattern in direct conflict with the Bail Reform Act, the court should consider the nature of the offense what Congress has instructed it to. Second, there's nothing unusual about the defendant being detained after being convicted only on Mann Act counts. So they give examples. U.S. v. Blake at the Eastern District of New York. They say the defendant was charged with sex trafficking and Mann Act violations and remained detained after pleading guilty to Mann Act violations. They say U.S. v. Kaiser in the Western District of Tennessee. The defendant was charged with sex trafficking and Mann Act violations. He remained detained after pleading guilty to Mann Act violations. Simply put, a criminal conviction, even one that the defendant erroneously suggests is novel in its application of the statute of conviction, is a far cry from the type of exceptional reasons sufficient to justify bail pending sentencing where mandatory remand applies. Okay? Let me see what y'all talking about here. Okay. Y'all all right over here? And they turned it into a criminal organization charge. Let me see. Yes, I need y'all to please hit the like button. I have seen unalivers get bail. That is true. This seems a bit personal. That's from Classy. Laura said, wow, this is unbelievable that Diddy isn't getting bail when others have been convicted of worse. I really hope President Trump steps in and pardon him. And he just might. And this response may be what make him go ahead and pull the trigger. Thank you, Felicia, for the super chat. I appreciate it. Thank you, Queen Brielle, for the super chat. Pretty Patty Petter, thank you. You said, let's get this goal on the road. Thank you so much for helping me meet the goal. Renee, thank you. Thank you for keeping us educated and informed. That's from It's the Rocks. Thank you so much. E Boogie, thank you so much for the super chat. I appreciate all the support. And so, first they argue procedurally, y'all not right. Secondly, they say the Mann Act is not that exceptional. It's nothing to see here. Like, people have went to jail on bond. I just gave you two examples. They've been on to jail, pending sentencing and didn't get bonds. I just gave you the examples. So yeah. M.O. Walker said it really seems personal. Lindell said denying bail is just weird at this point. They still fighting hard. I thought after Damian Williams stepped down, they was gonna be like, and then you got Comey getting fired. I was like, maybe they'll just be like, but they do have all these alleged people. The government does, and we've seen them on the internet. You have various people that are alleging circumstances and situations that they've had with Sean Combs working with them, and that they've experienced fear and violence. And they're going to list it out in here, which is interesting to me because a lot of them, if you ask the jury, they probably would have said they didn't even deem what they said was credible. But nonetheless, because some of them was a little iffy, like the balcony situation, Westmoreland kind of did one of her. She's done a lot of big ones, so I ain't gonna say she did her big one, but she definitely did the big one in that trial. To me, that was one of the big moments when she was able to point out the dates of that picture. Thank you for being a member for 17 months, Ambi Bambi. I appreciate it. All right, so they go over some of the cases that the defendant pointed out. The defendant first points out the conviction of John Tobridge, Michael Stabick, and Ronald Tills in the Western District of New York, and claims that because those three individuals were released on bonds following their guilty pleas, he too should be released on bond. But these defendants were all far less culpable than the defendant. And in fact, the government never sought their detention pre-sentencing, nor did the court appear to consider mandatory remand. And my thing about that, everybody knows about the Abercrombie and Finch situation and how all of them pretty much got bail. I think except one, because he had dual citizenship here and in a whole nother country. So he legit could have just left, went back home, and never came back. So I think he ended up being detained. But now you got Jeffries, who is saying, they're saying he's incompetent. But he originally, before the whole incompetency came, that allegation came, he got bond like immediately, and it was in the Eastern District. So maybe the Eastern District is more prone to giving you a bail. I don't know, but they definitely let him out, and him and his partner were accused of a whole ring where, again, it was international. It wasn't just even local. It was international. They were young boys, and there were allegations of people being stalked or them sending, I think they said they were sending camera crews or private investigators on the different people that were accusing them of this stuff, and threats of violence, allegedly. There were a lot of little things that the government responded, but they still responded giving him a bond. Now, some people say because he was old, that's supposed to be a reasoning that's different than Diddy. Because he was old, that's supposed to be one of the main reasons. Now, I don't know the age of his partner, but I believe he got bond as well. So he's out on bond right now pending his trial. And so it just seems that there is it's not clear across the board. And I get it. Everything is a case by case with every case. But when you look at that one to make it where his situation, I mean, just just focusing on what he was charged with to make it seem like it's just so much more egregious than what some of these other people are accused of. It's just, I don't think it's valid. So anyway, they say, the government being they, saying that these people were far less culpable than Sean Combs. And in fact, the government never sought their detention pre-sentencing. So the government didn't even try to have them, like, didn't even try to do it. And said that, and the court, they said the government, unlike the defendant, the government never tried to seek even any type of detention pre-sentencing, nor did the court appear to consider mandatory remand. So the courts, even though they were convicted of it, the court didn't automatically say, well, under the Bail Reform Act, you have to be remanded. And that, again, is what I was saying about Whitehead. Whitehead was out on bonds pending his trial. When he got convicted of everything, he went home, got on that camera, started showing all type of documents. Some stuff was under seal, some things allegedly he wasn't supposed to show, because he still wanted to show the public, I ain't do it. They convicted me of everything, but I really didn't do it. And a lot of stuff didn't come in trial. So he wanted to argue to us, the public, so that we could believe that he was not guilty. So the government at first filed an emergency motion that he had basically released or let the public see documents that were supposed to be under seal, and he wasn't supposed to let us know. Then after that, the government was like, bump that. I'm about to file a motion under the bond, on the Bail Reform Act, and say there's mandatory remand, because he was convicted of attempted extortion or something, which has something to do with threats and violence. So that is why I guess he was remanded. So when he came in, the judge was like, well, under the Bail Reform Act, he's supposed to be remanded. And that was that. So they're arguing that in these cases, even though they pled, the court didn't even consider mandatory remand. They just let him out, apparently, pending sentencing. And the government didn't even fight it. So apparently it depends on if the government decides to bring it up as an issue or something. Unlike the defendant, who transported men and women repeatedly for purposes of engaging in prostitution over the course of more than a decade, Stebic was convicted of conspiring to transport a woman across state lines for purposes of engaging in commercial sex work on a single occasion. So they're trying to say it's analogous, basically, that it's not the same. One of them was a single occasion, and the other one, which would be Diddy, was multiple occasions, and it was men and women, allegedly. Similarly, and Trowbridge admitted to transporting women across state lines on 2 occasions. And Tillis, who was sentenced to 18 months in prison, admitted to transporting women across state lines on 6 occasions within a 2-year period. And so they basically looked at their plea agreements. And again, this may have been what they pled to, because you have to give a factual basis. And the factual basis, you can go back and forth when your client pleads. So you can say, my client's not saying that. They're not going to do things to affect their appeal, because sometimes they have appellate rights, especially when you're challenging certain things. But you're like, no, they're not saying that. I've revised factual statements, like, for both to agree. And so it may have been, honestly, that they just pled, since they just pled to one. Like, that was a part of their agreement. So I don't think that's very strong, government. I don't. Because we know that people just plead to, a plea is just that, it's negotiated. So it may have been more, but the more there is probably will affect their sentencing. So they agree, okay, I'm going to plead to this one occasion and do a factual basis on it. It doesn't necessarily mean that the government didn't have more instances, just like when they dropped the sex trafficking in order for you to plead to this. But anyway, this is still their argument about the plea agreement, that they basically pled to just 1 occasion and 2 occasions and 6 occasions. Moreover, none of the Trowbridge defendants were alleged to have physically assaulted anyone in connection with the conduct, and Stebic transported the victim but did not have any actual contact with her. Further, both Trowbridge and Stebeck immediately admitted to their conduct, and both provided substantial assistance to the government, resulting in the government moving at sentencing for a downward departure pursuant to Section 5K 1.1. So what I would be interested in knowing, so then they say Atlanta residents, this is part of what, because they substantial compliance, right? So they assisted them, they became basically a witness for the government, gave them a bunch of information, and this is part of their plea deal, and that is part of why they got some of the leniency they got, because they became government witness. And so in this good footnote, it says Tillis also indicated to the government a desire to cooperate, and the government moved for two-level downward departure from Tillis's guidelines range. And then Atlanta, then in footnote 5, it has Atlanta residents convicted of interstate trafficking of a victim for commercial sexual purposes. So apparently they helped. We don't know what information they gave, which is very interesting to me, because if he only pled to a certain amount and it's a big old interstate trafficking ring, then it sounds like it was more to it. He just was like, I'm willing to tell everything, so I ain't got to do all the time. So I don't even think this is really a good analogy at all, because they just basically cooperated. So they probably got leniency. That doesn't mean that they didn't do some stuff. You know what I'm saying? They just decided to, cooperate. But anyway, the defendant also points to the conviction of Mario Collins, who was ultimately sentenced to 24 months imprisonment after he was convicted of a Mann Act violation for transporting a victim on a single occasion. Collins was released after a mistrial was declared on the charges against him, including sex trafficking and Mann Act offenses, and remained on bail after his subsequent conviction on the Mann Act charge. The defendant argues that he, like Collins, should be released, but this case does not bear the weight that the defendant attempts to place on it. At the point that Collins was initially released after mistrial, Collins was not subject to mandatory remand because, unlike the defendant, he had not been convicted of any offenses. So basically, I guess when the court announced that there was a mistrial, in theory, he wasn't convicted, so they let him go. But apparently they must have maybe re-brought the charges, is what it sounds like. They decided to retry him. And so once that happened and he was indicted, they gave him bail. So they're trying to say that this is different because he got a mistrial on the Mann Act. So when he walked away free from the actual mistrial, he was not convicted of anything. However, Sean Combs is convicted of 2 counts. Moreover, while Collins remained on bail after his conviction, it is entirely unclear whether the court even considered the mandatory remand provision. So the biggest theme here is when it came to the mandatory remand provision, they didn't even bring it up for these people. I don't know if that's a good thing to be talking about. They're using it in a way to say it doesn't affect Diddy because we brought it up, so it doesn't affect you. I think it's a problem, the fact that they didn't even feel like under the Mann Act they wanted to bring it up, which also to me goes towards Sean Combs' point of this is nothing that they're taking. They don't go as hard on other people that are convicted of this as they're going hard on him. So it kind of supports that. So the conclusions that can be drawn from the court's bail decisions in this case are limited at best, is what they're saying. Third, even if the court were to consider the facts underlying the convictions and considering exceptional circumstances, the nature of the defendant's crime reflect aggravating, not mitigating. So they're going to try to go above the guidelines. They're going to say these facts mean that you don't have anything to go below the guidelines. You need to go above the guidelines. So they're saying there are aggravating factors in his case and therefore support the defendant's detention, not his release. The court should reject the defendant's minimized version of his own conduct when he describes himself as a mere John. Far from being an ordinary and casual consumer of commercial sex, the defendant transported individuals for the purpose of prostitution on hundreds of occasions over the course of decades, plied Cassie, Ventura, and Jane, as well as male commercial sex workers, with drugs to ensure their continued participation in the days-long freak-off. Nope, I think they testified that they wanted drugs because this would help them get through it. And then also they got them themselves as well. And some of these, I think Jane might have been the only one that kind of said when she first met him, he gave him a pill and he gave her a pill and all of that. And she ended up in the shower or something. But yeah, and he had text messages, to my knowledge, from what I remember, that he was telling them he didn't want to use drugs at all because it takes away from his moments and his fantasies. But anyway, they say this is aggravating, that because he gave them drugs. Then they say he used violence against both Miss Ventura and Jane in connection with freak-offs, and employed a small army of personal staff to ensure that his every need was met during freak-offs. The defendant's actions surely distinguished him from an ordinary John. Wow, this is weak. Like, what? That is not what was coming out in this trial testimony. I know that's what the government was arguing, but yeah, they did have personal assistants that didn't know what they was doing. They just thought he was having a good little night, and they was setting all his baby oil and all that stuff out. But I don't see why that's just such a big circumstance. And the violence, remember, James said there was no violence at all that occurred during their relationship, except the one time of which she decided to take his head and slam it on a marble table and throw a bunch of objects at him because she thought he was with somebody else. And then that was their first and only violent altercation. Yeah. Finally, the court should reject the defendant's pages-long recitation of historic Justice Department policy as both irrelevant and misleading. In the past, the department had a policy specifically related to enforcement of the Mann Act, which focused on prosecuting the Mann Act in the context of commercial cases. But the department no longer has a specific policy related to the Mann Act. In fact, the department's current guidance includes a policy titled Prosecution of Customers Involved in Federal Sex Trafficking Offenses, in place since December 2020, which prioritizes reducing demand for sex trafficking by prosecuting those who engage in commercial sex with victims of sex trafficking, including buyers of commercial sex. See the Justice Manual, Section 8-3.400. In other words, it's squarely within the priorities of the modern day Justice Department to charge the conduct described above under a variety of federal statutes, including the Mann Act, which is exactly what the government did in this case. The defendant's suggestion otherwise relying on defunct policies is inaccurate and misleading. So they say the new policies is not what the defendant was citing. Those were old policies. So then they get into the MDC. They say that's not exceptional. The defendant claims that his conditions of confinement at the MDC are exceptional circumstances. For the reasons described below, they are not. In making this argument, the defendant relies primarily on Judge Furman's opinion in U.S. v. Chavez. In his opinion, which was published on January 4th of last year, over 8 months before Combs stepped foot in the MDC, Judge Furman found that the MDC's conditions at the time, in conjunction with the defendant's old age and serious medical conditions, constituted exceptional circumstances under Section 3145C. In doing so, Judge Furman described the conditions of the MDC at the time, which included extensive lockdowns, inadequate medical care, and problematic physical condition problems attributable in large part to the MDC staffing shortage. The defendant claims without evidence that these conditions, quote, have not abated, end quote, during his detention at the MDC. He is incorrect. During the defendant's stay at the MDC, the facility has made enormous strides in increasing and stabilizing their staffing levels, improving medical services, and improving physical conditions. For example, staffing at the MDC has increased dramatically. The Correctional Services Department at the MDC is staffed at 94.2% compared to 55% in January of 2024, when Chavez was published. Medical staffing has also increased, with the health department currently being staffed at 84.6% as compared to 69% in January 2024. The staffing has decreased the lockdowns described in Chavez. In 2025, the MDC had not, quote, locked down or modified its operations for any housing unit as a result of a staffing shortage. Medical care was also improved. In addition to increased medical staffing, the MDC has increased the use of telehealth services for quicker and more efficient medical checks for inmates. So now they get to go on video and they get to talk to a doctor. The MDC has undergone facility repairs and improvements, including in the past few months. These have included repairs of emergency call buttons, upgrades of security cameras, and improvements to elevators. So those are the improvements. Byron said, I swear these immigrants rougher on black folks than these southern white judges. I don't know what that means, Byron. Oh, Lord have mercy. Scorpio Vibe said they trying to drain that man's pockets until he broke and can't afford the dream team anymore. Sheesh. Thank you so much, Peanut said it. You said for all your hard work. Thank you for the super chat. I appreciate the love. Make sure y'all hit the like button on your way in. Thank you so much. And if you want to subscribe, please consider subscribing. So yeah, if anybody knows anybody in this chat that is over there at the MDC, let me know. Because I want to know, is what they're saying accurate? Is it way better? Did the turkey sandwiches improve? Are people no longer just falling over sick and not having care anymore, allegedly? Is things falling from the ceiling? Is it chunks of concrete? Like, what's going on over there? They're saying there's been improvement. But I'm saying when you starting from the bottom, improvement may not seem like a whole lot when you really wasn't really doing what you were supposed to do in the first place. But they're saying it improved by large percentages. It's not as bad as it used to be. Okay, so that is not an exceptional circumstance. When the judge made that statement, they said the times were different. Okay, let's go on. The judge ain't even said nothing yet. Why y'all going in on the judge already? He hasn't even responded. At least wait for his response. Okay. Given these improvements, Chavez no longer provides an accurate picture of conditions at the MDC or a basis to find extraordinary circumstances under Section 3145C. Indeed, Judge Furman himself observed more than 2 months ago that conditions at MDC are, quote, a lot better than when I wrote my opinion in U.S. v. Chavez, including with regard to staffing levels, medical services, and incidents of violence described in more detail below. In addition to Chavez, the defendant also relies on U.S. v. Colucci, and that's the Eastern District of New York case in 2024, and claiming there is, quote, unchecked violence in the MDC, which he says places his safety constantly at risk. But this, too, does not serve as a valid basis for a finding of exceptional circumstances. Like Chavez, the court in Colucci described violence that occurred over a year ago. Although there were instances of armed violence in the summer of 2024, those incidents have declined. An inmate contraband, though still a problem, is being addressed by the facility. Among other things, the MDC has dramatically increased staffing, as described above, and now houses more than 300 fewer inmates and detainees than in January 2024. The defendant perversely suggests that sweeping the jail for contraband and involving outside law enforcement agencies in doing so is somehow, quote, an admission that serious violence, mayhem, and chaos is occurring within the MDC, end quote, and proves that the MDC is mismanaged and unsafe. Quite the opposite. These steps were taken to improve some of the very conditions about which the defendant complains, and they have been working. Indeed, MDC is unaware of any violent incidents in the defendant's housing unit since his arrival in September of 2024. It is also worth noting the defendant's bail motion is devoid of any claims that the defendant himself was impacted in any way by the condition that he alleges. The motion does not make any specific allegations regarding the defendant's own medical care, exposure to violence, or experience with lockdowns. In fact, the motion is the first the government has heard of any risk to the defendant's safety, or for that matter, any issue with the defendant's treatment at the MDC, aside from his request during trial for additional time with his lawyers. To the contrary, defense counsel has repeatedly throughout the course of this case praised the MDC for its treatment of the defendant. So they got the examples. One quote from defense attorney was, "The MDC has been very responsive to us." A next quote, "The MDC has been very accommodating to us in many, many ways," end quote. The next quote is, "I want to thank the MDC. The MDC gave us good access to him. By failing to raise any issue related to the defendant's experience with lockdowns, medical care, his experience with the physical facility, or his safety to the government's attention, defense counsel, who did not hesitate to repeatedly raise issues of access to their client during trial, has deprived the government as well as MDC staff and the court of an opportunity to investigate, remediate these alleged conditions. They should not now form the basis of a finding of exceptional circumstances." So those quotes by the attorney has nothing to do with what they were alleging is wrong with the facility as a whole. They were just saying, and a lot of times, I think early on, part of why he was complaining about the access was because there wasn't enough access. Then after there was access, he gave them the same props when they started being more responsive and getting access. He also asked the court for support in making sure that they had proper access, because it is very difficult for you to defend someone who is locked up and you got this small amount of time. You also have so much you can bring into the jail. You have so much you can discuss. Again, there was a separate computer they had to set up for him to be able to look at the videos. The only thing on there is the evidence and all that. Like, it's way more than a client saying, come to my office at 5:00 and I'm going to show you your whole discovery packet. And then once I show you that discovery packet, some of this stuff you can peruse yourself and tell me what your thoughts are. It's it's different. And again, the government doesn't have to deal with that because they don't represent defendants. So they don't understand what the defendant would even be talking about. Then to say, oh, well, because they have some improvements but again, if you're starting from the bottom, anything is an improvement. Doesn't take much when you already at the ground to say something is better. You know how some people say there's nowhere to go now but up. So anyway, they say, given the vast improvements at the MDC, there can be no finding of exceptional circumstances, particularly here, unlike in Chavez, where the defendant alleges no compelling personal circumstances such as significant health issues or old age. So if you was older and sickly, then perhaps it may work, but because you're not, they're like, nah, bro. Like Judge Furman, other courts in the district have acknowledged that the conditions at the MDC detention facility have improved, including because staffing there has been increased. So they're looking at transcripts from somebody in May 21st, 2025 in US v. Burgos. There's another 2025 transcript in US v. Alexander that says all of those decisions that you read about were months ago. There's a lot more staffing at the MDC. The number of defendants who are ending up in lockdown for substantial periods of time are minimal. In addition, the defendant has not alleged anything near the individual circumstances that were relevant to Chavez. So they're making quotes of all these people that basically say the current conditions are better. And so now, even though in 2024, in those opinions where they talked about the MDC, y'all not going to use that as exceptional circumstances anymore because they're not exceptional because they made improvements. So then you had State v. Camacho look like they said in that case, I do agree that the MDC conditions are very unacceptable, especially these days. However, the opinion issued by Judge Furman with respect to Mr. Chavez is a very different situation than we have here. And Chavez, the individual, was 70 years old with significant health issues, and sending him to the MDC where health care was limited was seen as exceptional. And I do understand that. We don't have those situations here. So now they're showing where more judges are not considering that an exceptional circumstance. The court cannot and should not find exceptional circumstances based on the conditions of the MDC during the defendant's stay, particularly given the defendant's failure to enumerate any relevant individual circumstances. So then they're going to get into why he poses a danger and a risk. Okay, I'm going to go live now. I know this is very interesting to me. Like the legal wrangling back and forth. One of the things I said is because Diddy has a legal team, you get to see a fair fight. A lot of times you don't see a fair fight. The government has all the resources. They have all of the money. They can get all of the experts. Even when you have court appointments, you have to get permission for certain things. Your Honor, can I get an expert that's paid for by the government? Like court appointing is totally different in any realm, whether it's federal or state. So when you have someone that has money and they're willing to fight back and forth, but this right here is starting to appear more personal, like more so we lost because y'all lost. I don't care if you say you got 2 felonies or whatever. We lost. We got spanked a little bit. And so we want him to still be punished because there are people out here who believe that he is a horrible person. We've talked to hundreds of people and they all have this same experience with Diddy, and we weren't able to do anything to lock him away for a number of years. And I think they're a little salty about that. That's just my opinion. It just sounds, this whole responding and going, like, it just seems a bit salty. You know? Felicia said he's not a danger to the community. We knew nothing about any of the madness until Cassie opened her mouth once she realized she had no real funds in her account. And the thing about Cassie in response is that she was still communicating with him past 2018. She communicated with him. So why you lived your life, you moved on, you got married, you had kids. There is no evidence or information that past her leaving Diddy, because she did not leave him for domestic violence. She did not leave him for freak off. She left him because she was pissed off that he said that Kim Porter was his soulmate. That's what made her. She's like, well, what I've been doing all these years, I've been putting up with your BS, going through this, going through that, and whatnot, been your ride or die, and you say that's your soulmate? Oh, okay. So what have we been doing all these years? That affected her. So she was already dating her husband. And then apparently that's when she cut him off for good. And then she moved on. There's no indication that he was like, I'm peeking through your window. and all of that. Now, she did testify that she kept something by the door or something, I guess, just in case she lived in a bit of fear. It sounded like, but there was no testimony that he actually bothered her in that manner after they broke up. And again, so all of this is going to be premised on their relationship period, where they're holding him accountable for what he was violent for back then. Yeah, that's what was said. She was getting the D, even named her baby. If y'all don't stop talking about that baby, keep talking about that baby like that. So yeah. So anyways, this is the part about the defendant poses a danger to others. Even supposing that extraordinary circumstances could be demonstrated, the defendant fails to establish by clear and convincing evidence that he does not pose a danger to the community. As the court found less than 1 month ago, it is impossible for the defendant, having repeatedly conceded his propensity for violence at trial, to demonstrate by clear and convincing evidence that he poses no danger to any other person or the community. So because his team conceded, they couldn't do nothing but concede. The video is what it was. That is who he was. That doesn't necessarily mean that that's who he is currently. So what you are trying to convict him and punish him for already happened years ago. So that's why I'm saying, like, but that's what they're using, because there was a concession. And honestly, the judge is the one that brought that up. Didn't you concede that there was violence? But that doesn't mean he beating up and cracking people's head today. I mean, but that's what they're using nonetheless. Okay, so then they reference the transcript, noting that the defense conceded the defendant's violence in his personal relationships. And then they have another transcript quote, noting that the defense full-throatedly in its closing argument told the jury that there was violence here, and domestic violence is violence. We know that, but he wasn't saying he beating people up today. The court purportedly concluded that this type of violence, which happens behind closed doors in personal relationships, sparked by unpredictable bouts of anger, is impossible to police with conditions. So they're saying, because he was basically, the court had opined in its original opinion about bail was, listen, he's accused of DV, which is usually a secret. A lot of people didn't know that Cassie was getting beat up like that. And this is a type of violence that can never be policed because it's behind closed doors. That's what the judge said. The defendant presents nothing to disturb the court's finding, nor can he. The trial record is replete with evidence of the defendant's acts of violence towards others. The defendant's decade-long relationship with Ms. Ventura was defined by his repeated acts of violence and abuse. The defendant's temper and violence were unpredictable. The defendant frequently punched, kicked, and dragged Ms. Ventura, leaving her bruised and cut with black eyes and busted lips. This abuse often occurred during freak-offs, including the defendant's assault of Miss Ventura at the Intercontinental Hotel, which was captured on video surveillance. That was not during a freak-off. It was after a freak-off. But, tomatoes, I guess. This abuse often occurred during the freak-offs, including the defendant's assault. I said that already. Miss Ventura and other witnesses testified to numerous acts of brutality by the defendant against her. In addition, the defendant was also violent towards several of Miss Ventura's friends who witnessed his mistreatment of Miss Ventura, including Mia, Deontay Nash, Brianna Bongolian, that's the balcony lady, and Carrie Morgan, that is the best friend. The defendant was also violent towards Virginia, Gina, that's the one that didn't show up, who been all over Instagram living her best life, okay? She said y'all be stalking her, looking at all of her pictures and stuff. She's still here, she around, but she did not come up for trial. With whom the defendant was in a relationship at the same time as Miss Ventura. Remember, there was testimony by one of the former assistants that Diddy was throwing apples at her or something, like throwing some apples at her, but they don't know if he connected, but he was just practicing his arm, throwing apples at her or something. That was like what one of the former assistants said that they saw, and one of the reasons why they wanted to stop working for Diddy was because of how he allegedly was treating his women. More recently, the defendant brutally attacked Jane in June 2024, also in the context of a freak-off. As Jane testified at trial, after she initiated a physical confrontation with the defendant, she repeatedly locked herself in rooms in her home to protect herself from the defendant. The defendant kicked down each door. The defendant also kicked Jane's legs out from under her, picked her up in a chokehold, punched her in the face twice, punched her and kicked her repeatedly when she was on the ground curled up in a ball, and smacked her in the face 3 times while she was showering, resulting in Jane losing her balance and falling to the ground. Jane was left with a black eye and bruising and welts on her head. The defendant, who is significantly larger in size than Jane, had no visible injuries from the altercation. Under these circumstances, the defendant claims the violence against Jane was somehow provoked is disgraceful. So y'all don't think women can provoke violence, that they can't start hitting on you? They was like, no, it's disgraceful. Moreover, the fact that the defendant committed this vicious attack just 3 months prior to his arrest, and while he was unambiguously aware that he was under federal investigation, highlights, as the court concluded, a disregard for the rule of law and the propensity of violence. So with the violent incident, again, allegedly, she says she started it. It's supposed to have been resulted in a freak off, but they did not find him guilty of any type of trafficking when it came to her. This would have been sex trafficking. You basically made her have sex with somebody else after somebody beat you up with force and coercion. That is what it would have been. So somehow the jury did not believe either she was forced, coerced to have sex with the worker, which would mean that they may not have believed that this violence even took place to the level and the way that she described it. But nonetheless, this is what she testified to. So this is what the government is using. Okay. And then the defendant contends that he does not pose a danger because the trial record does not reflect acts of violence by the defendant between 2018, when he ended his relationship with Ms. Ventura, and 2024, when he viciously assaulted Jane. As an initial matter, the defendant's violent attack of Jane and his years-long proclivity towards violence against Ms. Ventura and others is more than sufficient to establish his dangerousness. But the defendant's suggestion that he went several years without inflicting violence on another person simply is not true. The defendant did engage in several acts of violence between 2018 and 2024. So it's redacted. As I said at the beginning of the video, it's probably because it was either deemed inadmissible, so it wasn't a part of the record and wasn't considered evidence for purposes of the jury making the consideration. Although this evidence was not presented at trial, the court is free to consider it in assessing the defendant's dangerousness. See U.S. v. LaFontaine, recognizing that proffers are permissible both in the bail determination and bail revocation context. The defendant's extensive history of violence and his continued attempt to minimize his recent violent conduct demonstrates his dangerousness and that he is not amenable to supervision. The defendant utterly fails to establish by clear and convincing evidence as required that he does not pose a danger to the community. So then they got the defendant is also a flight risk as well. Let me see. I'm looking at your comments. I'm behind. Tracy said, not one notification. YouTube do better. I hit the like button. Hit you. Yeah, I'm not their friend anymore. I don't know. I don't know. Classy said, I feel like something that we can't see is going on. That's how Classy. I do too. I'm like, this just seems a bit, it seems like a lot. It does. and maybe the government is trying to, aside from the fact that they got Woods, I think maybe the government is just trying, maybe they're trying to, there are people that are alleging they were victims and they're acting, they're saying, I'm not going to say acting because they may be scared. I wasn't there, but they're saying that they were scared and they're still scared of him. But a lot of this too is why Diddy was in jail. A lot of people was very brave and they were coming out and talking about it because I believe in their mind they thought all of those lawsuits, every piece of salaciousness on the internet, they thought it was going to be proved in this trial. People were very definitive that they knew he was going to end up going to prison for the rest of his life, and they felt like it was going to be a RICO, and they felt like Cassie was going to be the super shero that was going to do it. And so I think people were emboldened thinking he wasn't going to come back, saying things that may be true, may not be true, maybe somewhere in the middle. I don't know. I wasn't there. And then once it looked like he was coming home, folks got scared. Okay. I think people got a little nervous because they felt like maybe he was still on his 1999 or his 2007 and that something may happen. I don't know. But a lot of people went on shows and they didn't have no problem. Just like when I went over Ariel Mitchell's dismissal, all of a sudden it was the justice system did what it did. And, why are you picking on her? Everybody else was talking about it. Why you don't sue everybody? I mean, that don't mean he not going to sue other people. Okay. He may sue some other people. I don't think everybody's safe. But nonetheless, I think that that's really what it is. Like some people have said things, and I don't know the truth, the veracity of anything. And it may be all true, maybe none true. I don't know. But I think that once that occurred, people just felt a bit emboldened. And then when they thought he was going to get out, people got scared. And I think they relayed that. We had the letter from Nash. He gave a letter. We had a letter from Cassie. And I think somebody else might have submitted a letter as well where they were trying to keep him in jail. They felt like he was a danger to society. And it was because a lot of them were, they testified and maybe they thought that that's what it was. But we're at the finish line. Defendant is a flight risk is what's coming up next. Felicia said, honestly, that was my take on the case. I thought something totally different than what was brought out in this case. Never cared for Diddy until I saw that the case was bogus. Y'all know I was mad. I need to put a picture. I'm going to take a clip of that cheesecake video because that is what triggered me. And I was like, I'm not going to lie. So when everything first came out, I was part of the crew that thought they probably had a bunch of stuff on Diddy. I'm going to be honest. When it first came out, I was like, oh, they about to get you. All of this stuff, the powerful man is coming down that was able to cover up things because he had money. And then I read the indictment and I'm like, okay, this has nothing to do with anything that everyone's talking about. So it already made me a bit skeptical. Then after a couple of months, it was no superseding indictment. I was like, they said they're still investigating. Damian Williams did a whole press conference showing pictures of weapons and drugs and stuff that ain't had really nothing to do with this, like what was going to be charged. So I was like, okay, well, maybe they're still investigating. Then when they did the first superseding indictment and it just like clarified something or added a couple words, I'm like, okay, we're like literally 3-4 months before a trial. Then when they superseded it again in April, and I think they just named and added one of the unknown people. I think they just added, I think it might have been Jane or something. They added somebody on there. It was beyond, I have to look to see what it was, but it still wasn't anything adding minors or adding grapes from the Marriott and Lil Rod being on the boats. And it was none of the stuff that we heard. All of the civil complaints that we heard, the only person that was a part of this trial out of that was Cassie, except allegedly Jane, because it's alleged, people alleging who it is. And that name was actually in Lil Rod's complaint. Well, they didn't put the name, but he just did like an inference. Remember, Blackburn did an inference on who it was. So by the time I think January, I knew that the case wasn't what people thought it was going to be. And so I wanted to know, like, what was the purpose of all of this? Like, I just never saw Rico. Felt like if they, it was a lot of people that were going against me and, in the same field and profession. I was like, it is a Rico. No, that's not what its intent was. Yeah, any time a lot of statutes have been stretched when people are able to stretch them. They are, especially when we don't have anybody fighting them, adding to and expanding the purpose and all of that. Yes, it does happen and it makes bad law. But that doesn't mean that was the original intent, and that's what the RICO was for. Nikki said, why was he not charged with the guns with no serial numbers? If it was a kilo of cocaine, he would have been charged. So the purpose of showing the guns was to show part of threat coercion. Like, he goes around and he has them on his person. The thing is, we all know he has armed security. And I believe one of the security guards may have said that was his. But he has armed security. And so you can't necessarily prove that it belonged to him. He lives on an estate. He has house managers. He has hired armed security from a company. He has assistants, and people live on his properties aside from him and his family because of how big his home is, and also what he needs just to run his day-to-day life with what he does. So I don't know if that was like something they could have really proven, but it looks good in a complaint, right? It looks good to be like he walking around, because there was a story about the Suge Knight situation where he was seen at a diner and allegedly he jumps in the car and he got, they down for whatever, and people saw GUN. Same thing with Capricorn Clark. She said as well, she was in a vehicle and he had one on his life. He came to her apartment that night before the whole Kid Cudi situation happened, and he had one in his hands, and they were in a car and he had it on his lap or something like that. So that whole visual, like, to put it all together for you to kind of surmise that he does things out of threats and force, I think was the purpose of it. Yes, they claimed it was drugs in the baby oil. That was actually mentioned in that was actually mentioned, I think, in one of the complaints. Like, it was inferences, and then people talked about it because it was like, I was doused in baby oil, then my body went limp. They would say things like that to make that assumption that there were drugs in the baby oil. And I think Cassie or Jane or both testified that wasn't. They were just regular baby oil. Like, huh? He just liked glistening bodies all the time. He ain't want nobody with no ashy knees on his videos. He wanted everything glistening. He wanted to see the melanin skin glistening. Elite Leo said Ariel Mitchell Klein was the one who first said it was just in the baby oil. I remember her being on a platform, but I can't really confirm it because all this stuff is like, we've been talking about Diddy for the last 2 years, so I don't recall. But I know there was baby oil of which it was mentioned, I think, by Ariel Mitchell, if I recall correctly, and it had something to do with maybe one of her clients was saying how they felt once they had the oil on them, but I don't thoroughly remember. So TJ said the Suge story was so dumb. No violence happened that day, but feds asked everyone about it. Oh, really? You said a compound. Well, he lives on an island, actually, right? In Star Islands. So, and that was part of the issue too, is I'm assuming you gotta take a boat to his house or something to get to his home. So that was another thing. Like, nah, his transportation got to be on water. Like, nah. Yeah, that's what they say. Lindell said Cassie, Nash, Don Richard, Jane Doe, Breonna, and Moore all got caught lying on the stand. They have zero grounds to make. Okay. Let's do this last part. The defendant is a flight risk. So this is why they're saying he's a flight risk. The defendant also fails to establish by clear and convincing evidence that he is not a flight risk. The defendant faces significant penalties for his crimes of conviction. As raised in the government's July 2nd, 2025 submission, the government's initial view was that the defendant's guideline was 51 to 63 months. The government is continuing to assess the sentencing guidelines, aka they trying to find ways to give you more, and expects that the appropriate guideline range will be substantially higher. So even though they said 63 months was what their guesstimate was, they're digging as deep as they can all the way back to the 1800s so they can see a way so they could smack them upside the head with this sentence. Okay, that's basically what they're saying. We suspect that it's going to be substantially higher. And U.S. v. Fishman, moreover, the defendant's endless financial means, coupled with his demonstrated ability to conceal his crimes, his past efforts to bribe security officers, as well as his general disregard for the rule of law described above, serve collectively to create a substantial risk of flight. Accordingly, the defendant has also failed to demonstrate by clear and convincing evidence that he does not pose a flight risk. For the foregoing reasons, the defendant's motion should be denied. And that is signed Jay Clayton, who is the interim U.S. attorney over there at the SDNY, Meredith Foster, Emily, Christie, Madison, and Mitzi. So that is the motion response to the bail that was filed by this here United States of America. And I think, I don't know if the judge has seen anything new that would give him a lot of the stuff that they said was something that was brought up. They just kind of expanded on it more. So I don't know if the court is going to see that it was anything new that was posed. And because of that, I think that I almost feel like they wrote this sentencing memo because they have an expectation of a pardon or something. That's how I almost feel now. Because it really is kind of similar. And I think they wrote it out so people can see how unfair this is. And so if you see it's unfair, then that means those over there in that pardon department with Trump and all them, they'll see that it's unfair as well. And they can use that as a guidepost. And then this response that basically is almost like, because I don't like you, in a very professional way. Maybe what they were gunning for. I'm just saying, we'll see. But anyway, that is the government's response. Do you guys think that their response was great? Do you guys think that they did what they were supposed to do? Mark said the prosecutors use a lot of speculation. The defense shows receipts. Okay. Let me see if the judge put on a date, y'all. Aldrich said, has the judge given a hand? They just filed the response. Aldrich, relax. They just filed it. Yes, they do have to respond to that as well. They're going to respond to the motion for acquittal. Classy said, this is not justice, said judges. This is not justice. Juan said, we're white and we said so. know what? KP said Diddy has been denied bail in the past, present, and now future. He has been. That is true. Let me see if the judge has given a perhaps date of which there may be a hearing. Let's see. Let's see what we have here. Nope, we don't have that as of yet. Nikki, thank you for the super sticker. I appreciate it. All right, I'm going to jump off here. I'm going to do a brief membership live. So if you are a member, head on over to the membership. I was on the hearing for Blackburn and Fat Joe today. I was over there at Danielle's little swimming practice, still listening to the hearing. So we're going to talk about that over in the membership for those that care. But until next time, thank you guys so much for helping me reach my goals. Please make sure you hit the like button. And if you're new here, consider subscribing to the channel. And we also have a membership. Come on over and join us to the membership. We have some fun over there. And I'm going to talk to you all later.